This is one of the most gruesome crimes that I've seen. Now, we are waiting for the jury to come into the courtroom, so court has not yet resumed today. In the meantime, I want to bring in trial attorney Kelly Hyman, who is joining us. Thank you so much for being with us this morning. One of the first things I want to talk about, and you could see on some of the footage we just showed from the body cam, and that is that some of the pieces of the crime scene are blurred out, as well as in the photos. And it's my understanding the jury is seeing photos that are blurred out for some, for instance, the severed hand, the head in the pot on the stove. Let's talk about prejudicial value of evidence and why perhaps these things are being blurred out.
Yeah, Jez, that's a really good point. And first, thank you so much for having me on the show. I really appreciate it. You know, it's a horrific crime. I mean, it's out of a horror movie. I mean, also, you know, if there's too much prejudice that outweighs the probative value, then I think that that's why they blurt it out. So that it's just too much for the jurors to see that information. You know, it'll be interesting to see what the defense come up with in regards to the defense, because as far as I know, there's no insanity defense, and so I wonder what their argument is going to be in this case. You know.
Oh, that's a really great question. And we've been talking about that here at Court TV. And one of the questions is, you know, a defense attorney obviously zealously represents their client, right? And the client makes the decisions based on the advice that the defense attorney gives. So one of the things I wonder in this case is, number one, is there a defense? What is it? And number two, how strongly counsel may or may not have encouraged the defendant to consider a plea deal. I'm not saying he's guilty, presumption of innocence, but I am saying the evidence that we're seeing at this point and have heard that will be introduced suggests that there's pretty compelling evidence. So why in your mind would a criminal defense attorney choose to go to trial if in fact there is very compelling evidence against him?
Well, you know, as you know, ultimately, you know, you're innocent until proven guilty. And so the prosecution has to prove their case. They have to prove by the evidence that the person is guilty. And so, you know, that the prosecution needs to put their case forward and prove it. But basically what you said, it looks like there is a lot of evidence. And as you said before, you're innocent until proven guilty, but it'll ultimately be up to the jury to make a determination based on the facts of whether he's innocent or guilty of the crime. But no matter what, this is a horrific murder. My thoughts and prayers go out to the members of the family to have a loved one die like this. I mean, this is just horrible. The head in the pot. I mean, this is just horrific. Yeah. No one should have to go through this.
Absolutely agree. It's really impossible to understand. I do want to go back to the compelling evidence piece that we were discussing and listen to the prosecutor as she details in her opening statement some of the notes found in the backpack allegedly belonging to the defendant.
Get plastic bin for denaturation process. And I guess that means for dissolving your parents. Does not matter where they're killed. Just get rid of bloody spots to prevent evidence of time of death. Not the mattress or couches. Get hollow point bullets just in case. Will be seen buying bullets. Just use computer room gun. Check to make sure there are bullets, last resort. There were no gunshot wounds to the victims. He's not alive to claim her half of the insurance money, all mine, $500,000.
So, Kelly, I have to point out there were no gunshot wounds, but I will say on the body cam and in the testimony, there are guns on one of the tables. So do you think that's enough to argue, listen, even if some of the things in the notes weren't done, it may have been because he fled or ran out of time?
You know, I think that's a really good point. And I think, you always wonder, why does someone do something? And you look at the note and it talks about money. And show people at the juries always want to think, you know, what is the motive? Why does someone do something? And that's really strong evidence that money was involved and the reason of the crime was for money. So I think that that's a very strong, you know, letter and very powerful for the jurors to see.
And even though motive's not an element of a crime, as we all know, it certainly is something that helps to have by the state, because the jury, like you said, Kelly, I completely agree. They want to have a reason. They want to understand what the reason in this person's mind was behind the crimes that they committed. And these are such gruesome crimes. It's really hard to imagine how a jury can say, look at the horrificness of it, and yet we have to imagine that and presume that he's innocent. But the reality is that's our criminal justice system. It's an excellent system, and I believe in our system. Now, let's talk about, though, he has been very actively involved in his defense in terms of motions that he's filed and what he's wanted his attorneys to do. Based on that, do you have any prediction as to whether or not you think we're going to hear from the defendant on the stand?
That's always the $64,000 question. And so it's, ultimately it's up to the defendant to make the determination. Now, the attorney can advise them and say, yes, I think you should testify. I really don't think that you should testify. But if I was a betting person, I would probably say that he would not testify. As I said before, the prosecution have to prove the case. They have the burden. They bring the case forward, and they have to prove all the elements of the crime. And if they don't do that, and if the jury comes back not guilty, then the prosecution hasn't proved their case. But ultimately, we're going to have to see if he takes a witness stand or not.
Yeah, that is the million-dollar question. Now, we know that no one was an eyewitness. We don't expect anyone to say, yes, I saw him do this to his parents. But the state has to put together all of the evidence to show that he did commit these crimes.